All right. Well, good morning, everybody. My name is Jonah Trotz. I'm an associate in Farella, and Martell's Real Estate Industry Group. Thank you all so much for joining us this morning for the second event in our ongoing real estate education series. These panel discussions are going to continue over the next several months, and we'll make sure to continue sending you invitations to our future events. Today, we're going to be discussing issues, lessons learned, and practical considerations related to the COVID-19 pandemic in commercial leasing. So with that, I'd like to introduce our three amazing panelists for today: Tony Schoenberg, Margaret Duskin, and Marsha Ramsey. Tony Schoenberg is the chair of Farella's Business Litigation Group. His practice is focused, among other things, on real estate litigation, and he has extensive experience in resolving a broad array of real estate-related disputes. Margaret Duskin is an executive director with Cushman and Wakefield and is recognized as a leader in office sales and commercial leasing in the San Francisco Bay Area. Margaret has leased or sold over 10 million square feet of commercial property and specializes in complex deal structures, advanced lease negotiations, commercial property sales, and corporate strategic planning. And last but certainly not least, Marsha Ramsey is the Northern California Managing Director at Cushman and Wakefield, where she has been since 2012. As Managing Director, Marsha oversees Cushman and Wakefield asset services comprised of over 62 million square feet of under management from Sacramento to San Jose. And as you can all imagine, all three of our speakers have been working on COVID-related issues over the past year and a half. So today we're going to be discussing some of the practical considerations at this point in the pandemic. And with that, I'd like to turn things over to Tony Schoenberg, who's going to tell us about the status of the commercial eviction moratoriums. Tony?
Yeah, great. Thank you very much, Jonah. I appreciate it. A few words about eviction moratoriums to start. I'm focusing today just on commercial eviction moratoriums because the focus of our program today is commercial real estate and commercial leasing. As you may know, there was a statewide residential eviction moratorium that was passed at the beginning of this year, SB 91. SB 91 is set to expire at the end of this month, and I do expect that in the next couple of weeks, we will see some sort of legislation that probably will extend that for some period of time. So if residential is your focus, keep your eyes open in the news over the next couple of weeks. On the commercial front, however, as you might know, there was no federal or statewide eviction moratorium enacted during COVID. The action all took place at the local level, and it was enabled by an executive order that Governor Newsom issued on March 4th of last year, which basically said that state laws would not preempt local laws that implemented commercial eviction moratoria. Basically, the governor said it's okay for local municipalities to do that. And so many, if not most, counties and cities in California, particularly the big commercial centers, did in fact enact commercial eviction moratoriums. And so I'm going to focus today on some of the details of several of the big commercial centers here in the Bay Area. Incidentally, over the last week, Governor Newsom signed a new executive order which extended the ability of municipalities to have commercial eviction moratoriums through the end of September. So that was actually part of an executive order that addressed a whole bunch of different orders that the governor had issued during COVID. Mostly, he was putting expiration dates on them. And so the expiration date for the moment on this particular one is September 30th. It is theoretically possible that that will get extended further and that there may be a longer period of time during which commercial eviction moratoriums are in place, although it's very unclear really at this point whether or not it will get extended again. The last bullet point on this slide about AB 255, for those of you who've been paying attention, there was some legislation that was introduced in the state assembly recently that would have provided, it basically was a very tenant-friendly piece of legislation that was directed at commercial tenancies, and it would have provided some sort of rent relief and some other similar provisions. As of sometime in the last week, it's basically that's done. It did not pass. It didn't make it out of the assembly. So if you've been following that, that legislation is not happening. Next slide, please, Jonah. So I'm just going to quickly go through some of the basics of the eviction moratorium that are in place in San Francisco, and then Oakland, and then I will cover Santa Clara County. And so let me start with San Francisco. San Francisco's commercial eviction moratorium applies to commercial tenants and subtenants, including nonprofits that meet these two criteria. They have to be registered to do business in SF, and they also have to have had combined worldwide gross receipts of 25 million or less in tax year 2019. And if a commercial tenant or subtenant meets those criteria, and going down to the bottom bullet point, if they missed a rent payment between March 16th of last year and September 30th of this year, which is considered the moratorium period, and the missed rent was due to COVID-19 related financial impacts, then that tenant cannot be evicted for non-payment of rent unless the rent remains unpaid after a forbearance period. And San Francisco's commercial moratorium is a little more complicated than most. They have enacted different forbearance periods for tenants of different sizes. So Jonah, could you go to the next slide, please? You'll see it's a four-tiered structure. Tier 1 tenants are defined to be tenants that have 10 or fewer full-time employees, and they actually get a forbearance period of 2 years. So basically means they have until the end of September 2023 to pay any rent that was unpaid during that moratorium period before they can be evicted. Tier 2 tenants are defined as tenants that have between 20 and 40 full-time employees, and they get an 18-month forbearance period. So they have until the end of March 2023 to pay any rent that they missed during that moratorium time period. Tier 3 tenants are those that have between 25 and 49 full-time employees. The forbearance period for Tier 3 is 12 months, so through the end of September next year. And then Tier 4 is defined as entities that have 50 or more full-time employees, and they do not get a forbearance period. So for those entities, rents will be due at the end of September of this year. That is rents that were not paid during the moratorium period. So a couple other points about San Francisco's tiered system. Tiers 1 through 3, tenants that are in tiers 1 through 3, they can pay back rent in installments or in a lump sum up to the expiration of the forbearance period. So theoretically, they could pay all of the rent they missed during the moratorium time on the last day of that forbearance period, and by doing that, they make it so that they cannot be evicted. And the moratorium provides that payments that are made are applied first to rents that come due during the forbearance period, which makes it so that tenants are able to catch up on the rent without being evicted for missing their current rent during that forbearance period. Tier 1 tenants, can you go back, please, Jonah? Tier 1 tenants, which are the smallest one, 10 or less full-time employees, actually have the ability under this moratorium to terminate their leases early if they are unable to pay rent due to COVID-19 related financial impacts. Next slide, please. Couple other interesting things about San Francisco's commercial moratorium. It has a big exemption, which is that it does not cover tenants or subtenants that occupy space in property that is zoned or approved for office use. That is unless the tenant or subtenant is a nonprofit that has valid 501c3 status. So that's a pretty big exception. It basically means that all of this office space we have in San Francisco is exempt from the commercial moratorium in San Francisco. And as per bullet point 2, tenants who sublease are considered landlords vis-a-vis their subtenants. So this commercial moratorium does apply to sub-tenancies, and in those sub-tenancies, the sub-landlords are considered landlords and have to comply with the moratorium, and the sub-lessees get the benefit of the moratorium. And on the last point, landlords under this moratorium are not permitted to assess interest or other charges based on unpaid rent that fell due during the moratorium period. If rent is still unpaid at the end of the forbearance period, they can then charge interest and penalties prospectively at that point in time. Next slide, please. There is, as per this first bullet point, in San Francisco, there is a possibility under this moratorium for commercial landlords to basically get an exemption from the moratorium in certain circumstances, specifically landlords who own less than 25,000 square feet of gross floor area and who are able to demonstrate that a significant financial hardship is created by their inability to evict, may be able to actually do an eviction, notwithstanding the moratorium. Now, I'm not aware how frequently that has actually been, how many landlords have really availed themselves of that during COVID. So I'm not sure that that's actually been taken advantage of much, or how that has played out in the courts, but that is part of this moratorium, which distinguishes it from most of the other moratoriums that I've seen. And then this last point, the moratorium does not relieve tenants from liability for unpaid rent, nor does it prevent landlords from seeking to recover rent that's owed. It is merely a moratorium from being evicted. So it is protection against eviction, but it is not protection against having to pay rent. And landlords could go to small claims court to try to collect unpaid rent. They simply are unable to evict until the applicable forbearance period has expired. Next slide, please. So I'm going to go on now to Oakland, and it will become clear as we go through this that the different local moratoria, to use the plural, are actually quite different, and each one is pretty unique. So in Oakland, Oakland's commercial moratorium covers small businesses, as that term is defined in the California Government Code in section 14837D, and it also applies to nonprofits. And to qualify as a small business under section 14837D, there are three criteria. One is that the entity has fewer than 100 employees. Two, the entity has to have annual gross receipts of 15 million or less. So it's narrower than San Francisco's moratorium, which is applicable to entities that had gross receipts of 25 million or less in 2019. And then they have to have a principal office that's located in California, not necessarily in Oakland. One interesting point is that the way Oakland wrote their moratorium, technically, it seems to cover all nonprofits, regardless of their size. I think that was probably a quirk of drafting, because I doubt that Oakland intended that enormous nonprofits, like, for example, Sutter Health, would be able to avail themselves of this moratorium. Anyway, that's just sort of an odd drafting quirk in Oakland. I don't know that there's ever been an issue related to that. In Oakland, if a tenant is covered, qualifies under those criteria that we just discussed, then that tenant cannot be evicted for failure to pay rent if non-payment was caused by a, quote, substantial decrease in income, including but not limited to a decrease caused by a reduction in hours or consumer demand, caused by COVID-19 or a governmental response to COVID-19, and the income decrease is documented. And Oakland, like really most of the municipalities who've enacted these types of moratorium, has tied the duration to the governor's executive order. So as of now, it is extended through September 30th, 2021. Next slide, please. Like San Francisco, the Oakland moratorium does not relieve tenants from liability for unpaid rent, and it does not prevent landlords from seeking to recover rent that's owed. It's merely a protection against being evicted. In Oakland, under Oakland's moratorium, there are no restrictions on late fees being imposed by landlords for unpaid rent during the moratorium time period. There is a limit on rent increases. It is limited to the consumer price index, which is around 2.7%. Rent increases above that are prohibited. Next slide, please. So I'm going to go on now to Santa Clara County, which has a commercial eviction moratorium that is somewhat different from the other two that we've just discussed. Santa Clara's moratorium applies to small business tenants, but the definition of small business under Santa Clara's moratorium, unlike Oakland's, which is based on a California government code provision, is instead based on the definition of small business set forth in the Federal Code of Regulations, 13 CFR section 121.201, which is actually the section of the CFR that covers small business administration loans. And under that CFR section, there are size standards that determine whether an entity is considered a small business, and they vary depending on, they vary by industry, I should say, depending either on the number of employees or the annual receipts. And if you go to that link, which is on the Small Business Administration's website, there's a very long multi-page list that sets forth the different size standards that determine by industry whether an entity is considered a small business or not. And in Santa Clara, nonprofits are also covered by the moratorium if they satisfy those same standards. So like Oakland and San Francisco, the Santa Clara County moratorium's duration is tied to Governor Newsom's executive order. So at present, it is extended through September 30th. And the way Santa Clara's moratorium works is it provides that if a qualifying tenant has suffered a substantial loss of income or substantial out-of-pocket medical expenses as a direct result of the COVID-19 pandemic, then they can delay paying their rent under this two-pronged framework. They get 6 months after the expiration of the moratorium to pay at least 50% of the past due rent that was deferred during the moratorium. And then the remainder of the rent is due at the end of 12 months after the moratorium ends. And so if they are able to do those things, then they cannot be evicted for non-payment. And as per the last point, the landlord may not charge a late fee for rent that was due during the moratorium if a tenant follows this framework. And I think that is all that I have on my discussion of commercial eviction moratoriums. So I'm going to throw it back to Jonah.
All right, thank you, Tony, very much. And with that, we're going to turn things over to Marsha, who, as someone who works in asset services, is going to be able to provide a landlord perspective on the current leasing issues we're seeing at this point in the pandemic. So, Marsha.
Thank you, Jonah. I wanted to just dovetail a little bit on what Tony just said about the evictions and kind of what are the landlords considering. Our clients and our owners are at this point in time, trying to determine whether, they need to pursue an eviction when all of the moratoriums or moratoria are lifted, or lease terminations. Obviously, they're taking into consideration the financial state of the tenant. Do they have the wherewithal to pay the rent? Is the tenant contemplating bankruptcy? Does it make sense to terminate the lease, anticipating that the courts are going to be pretty backlogged at some point in the future? Or should they make additional rent modifications to keep those good tenants for the long haul? So there's a lot of things that have to be considered. During this period, we took just a really quick survey of some of our San Francisco CBD Class A and Class B properties. And we found that the tenants who sought rent relief were mostly the small non-institutional tenants. And this 14% is just, kind of a really quick dive into, buildings that have been impacted and not necessarily a full study. Large institutional tenants, I think you'll agree that very few of them requested it and very few received it if they did. And then retail obviously was the biggest hit. We're looking at, somewhere around 56% of retail tenants had sought some form of rent relief, and that could also be a termination as well. And on to the next. So what is happening as people are coming back to the office? The focus is definitely on indoor air quality. People want to work in an environment where they feel safe. We are seeing many owners focused on Fitwell, well building standard, and LEED certification. These certification programs allow them to measure wellness of the built environment, such as indoor air quality, and it provides reassurance to the employees the workplace is recovery ready. Management teams are installing MERV 13 and above filters, and when possible, management teams and the engineering teams are increasing the number of air changes throughout the day, and they're flushing the building's air systems early morning and again at the end of the day. So changing COVID protocols. Boy, we are right in the midst of changing COVID protocols as of today. But we do expect this to evolve in the weeks ahead as the tenants and the employees are more comfortable returning to the office. Those screens in the lobbies will be coming down. The elevator passenger limits have been removed as of today. Tenant policies on employee vaccinations. One study has that less than 15% of tenants are requiring their employees to be vaccinated. And vaccination confirmations by employers. There's only one county, and that's Santa Clara County, that is requiring employers to collect that information and provide that to the county. ESG, this is the environmental, social, and governance initiatives. Our institutional owners are fully engaged in ESG, and we're helping them to identify, implement, and track environmental and social performance metrics. We're also finding that tenants are quickly adopting ESG performance standards and will want to be in a building that has an ESG program in place. And some examples of ESG initiatives include environmental initiatives like energy and water efficiency and waste management. It also includes social initiatives that include vendor contracts and spend with diverse owned businesses, just to name a few items. And then next, what are the impacts on operating expenses? Well, in San Francisco, we know that there are, the janitorial union just completed their collective bargaining agreement negotiations. Those negotiations are going to impact increase janitorial pay 30 cents per hour beginning January 1, so that's retroactive. It will then include an 80 cents per hour increase beginning August 1st of this year. And August is the usual adjustment date. So every August in next year and the following, we'll see another 10 cents per year for janitorial wage increases. And there's also seniority benefits and health insurance increases that will take effect in 2021, which will also impact janitorial costs. Security costs, we expect those to go up as staffing increases from the skeleton staff levels that we're seeing currently. Janitorial supplies, we've seen pricing increases throughout COVID that have occurred each month, due in large part to supply chain disruptions. But as the shortages are being addressed, the prices do come down. Unfortunately, they never come all the way back down. And we are projecting a 7 to 10% increase for the year, but fortunately, consumables are not a large part of the operating expense budget. Insurance premiums, based on Cushman & Wakefield's PACS property insurance program and our own benchmarking, we are seeing property insurance premiums increase year over year. This is not just in 2020 and 2021, but it's been occurring for the last few years. But in 2021, we are projecting an upward increase of 15%. General liability for office remains flat, at least for this year. while other property types have seen an increase of somewhere between 12 to 14%. Excess liability is also around 12 to 14%, with some limits on coverage and also increased deductibles. And wages. Even prior to the pandemic, we were seeing wages rise due to basically the low unemployment. And now with talent on the move, we continue to see wage increases as employees reassess their work-life balance, and they're choosing jobs which are closer to home and to childcare, and there's other factors that go into that as well. So what is the impact on 2020 CAMs and our operating expense true-ups? So these have been completed for most properties by this time, and most buildings and tenants are going to see slightly lower costs in 2020, even with the gross up and adjustments for occupancy. And this is due in part to some of the building staff reductions that they have implemented, or due to delays in some of the repairs and maintenance projects.
One I might want to add here, Marsha, is that tenants and landlords need to check their lease language as to audit dates, outside dates for audit claims for both parties. They want to be aware of that. And because things may have been delayed going out this year, it doesn't mean that the lease language provides for that kind of delay. So people should be aware on either side of the equation when they can audit, how quickly operation expense reviews can be put to the landlord or taken up by the tenants.
Yeah, that's right. And any lease with a 2020 base year really does have a high probability of being audited. And this is really, tenants want to just ensure the consistency in those calculations.
Right.
So on work from home is here to stay. When are tenants returning to the office, and what does that look like? That's a big question. Some tenants have asked their employees to already begin returning, and we're starting to see building occupancies increase just in the last few weeks from 5 to 10% to over 20%. And that is occurring on certain days, obviously. The Wall Street Journal reported that 61% of employees will be back in the office by September. And that date has a lot to do with in part with summer vacations, waiting for schools to open up in the fall, and just an overall comfort with some of the people getting used to getting back onto mass transit. But because work from home will be an option for many of our tenants, at least 1 to 2 days a week, and though it is hard to project, we are expecting building occupancies to remain below pre-pandemic levels for the rest of the year. We know that work from home is popular with tech employees. It's not an option for every employee in every company. So that is going to have a positive impact. And another positive impact is on parking garages. We're anticipating that downtown San Francisco parking garages are expected to see higher utilization than pre-pandemic levels. And for the future for retail tenants, most CBD office buildings, the retail is not a large component of the revenue stream. Food service is highly dependent on employees being in the workplace. And those food service tenants who remained open will see a surge in business as employees come back, and options are limited due to the closures during the past year. So that's all I have to share today. And so I'm going to turn it back to Jonah.
All right, thank you, Marsha. With that, we're going to turn things over to Margaret. While Marsha comes from a more landlord-oriented role, Margaret primarily represents tenants. So in discussing these current leasing issues, we're going to get a different perspective from her. Margaret?
Thank you very much, Jonah. And just to follow up on one point that Marsha made, the impact on parking garages, we have seen in the studies that we're doing, looking for new space for tenants in the San Francisco business district, the desirability of parking is way up. Although people believe that BART and Muni are going to be safe someday, I'd say for the next 12 to 24 months, buildings that have parking are in high demand as opposed to those that have no parking garages and are relying primarily on public transportation. So now that we've kind of linked a little bit here, let's go on to the pandemic issues that we have never faced before in leasing. So, I've been around several decades, and having the government shut down the operation of business is a new one for me. I've been through the 1989 earthquake, I've been through the dot-com implosion, but having the government shut down your use of office space and retail space is right off the charts in terms of new impact on leasing. What we found are, although people like Marsha have been keeping open 62 million square feet of commercial space in the Bay Area, the government has not allowed tenants to come into the buildings or to come in a very limited basis. So even though the buildings are open, which was very wise of the landlords, the fact that we couldn't use the space as tenants has been a very negative impact on our bottom lines. It's very strange when you show space and you can see people's coffee cups from March 16th still on the desks and the papers are there, but nobody's been there in a year and a half. It's a little neutron bombish, actually, if you want to have an old reference. But what are we going to do about this in leasing? How are we going to address our health and business government restrictions and guidelines? Is there a way that we can now implement future rent abatements and negotiated concessions in the event that this happens again? Today we have COVID-19, but we also have the Delta variant. Is there going to be another episode of this or some other pandemic that will require people to stop working from the office environment? If that's the case, why not sit down today while we have this experience fresh in our minds and look at how we can negotiate or pre-negotiate concessions and rent abatement or rent restructuring. I think 6 months of last year I spent most of the time renegotiating rent payments, rent streams, rent abatement, tying things to PPP loans. Happily, Tony, I've never had to use your services as far as litigation for collection as a sub-landlord. But today is a time for us to look at that language, and I'm sure that Jonah, you, Greg Sheen, and Tony are all looking at the language in the new leases that you're drafting to try to address this. Why not be prepared? If the government shuts down the use of your space, whether or not it's available through Marsha's management team, how will that impact your rent stream? Work from home is a new normal, and it's going to make people look differently at how space is used. We're designing spaces that are meant to be attractors of tenants to return to an office environment. People have gotten very comfortable, or some people have, working from home. So are they going to commute an hour and a half each way to come back to the old office? I don't think so. Today, we want to attract people to come back to our environment, to be bonding with our peers, to be creative, to have a sense of camaraderie with our corporations. And to do that, we have to overcome the comfort level of work from home. One of the things that came up in our experience over the last 15 months is how do we get TIs and base building work constructed? The issues that we have with permits and construction, I'll talk about those in more detail later. Jonah, would you mind moving on? One of the things that I've seen very prevalent now is expansion of language regarding condemnation and government regulation. Today, we really need to look at leases as this experience is fresh in our minds to say, this is not a permanent condemnation. This is a government regulation that allows us not to work in our typical environment or not to provide retail services. And this is why we're addressing these kinds of terms in our lease negotiations today. We don't want to have restricted to a permanent condemnation if it's a temporary restriction of use. And Jonah, you may have talked about that with some people lately. Want to chime in here?
Yeah, I don't think I have too much to add to that other than to say I think that's definitely a hot topic and something that's definitely on people's minds as they're negotiating these leases. And not to jump ahead too much to your next bullet point there, but for both condemnation issues and force majeure issues, just being very cognizant of pandemic and epidemic issues, and not only the effects of the pandemic itself, but the effects of the government response to whatever event may arise.
Exactly. So just linking those together, force majeure should now be expanded to include health calamities, and not just earthquake, fire. Of course, we have plenty of smoke in the Bay Area, but now let's include the health pandemic issues that have been raised by this dreadful last year. If you could get both of those to have an expanded provision level in your leases as a tenant, you'll be better off. And actually, landlords will probably also benefit, because having these things defined rather than fight them out on a piecemeal basis, it's just better for tenant and landlord long-term relationships. The other issue that we found hugely impactful is the delayed delivery. And what we're trying to do to forestall this in the future, in the event we have another pandemic and we have issues with supply chain and labor interruptions, is to allow for rolling commencement dates. Oftentimes the lease will say, all right, after 3 months of the landlord failure to deliver, the tenant has the right to cancel. Well, this is out the window now. The tenant can't cancel because there's nowhere else to go. The tenant also probably still wants the space, even though possibly at a reduced size with the work from home impacts. So what we're trying to do in our current negotiations is allow for a rolling commencement date, whether tied to permit and government delays or supply chain. So this links directly to the force majeure. And we look to people like Jonah and his colleagues to help us craft language that allows tenants and landlords to keep a relationship of a lease or a pending lease going without having it terminated unjustly for either party. One of the other aspects that we're looking at is expanding the tenants and the landlords' interruption insurance. Business interruption insurance for tenants and landlords' rent interruption insurance definitely must be expanded. And Marsha said the cost of insurance is going up 10 to 15%. Well, when we start packing in all the other aspects that we want covered, I think it'll probably go up to 25%. But what people are realizing is that our former rent interruption insurance or our business interruption insurance is inadequate unless it specifically required pandemic or other kind of business interruption by governmental regulation, whether temporary or permanent. So next slide, please. As tenants are returning to the office, we're looking for a more effective use of space. Interestingly, the direct space in the CBD in high quality buildings has not dramatically reduced in rent. However, tenants are overcoming this increase in rent over their past 7 to 10 years by downsizing and becoming more efficient in their use of space. And we're using techniques which were actually started by Accenture and my old alma mater, Ernst & Young, called just-in-time office utilization, where you have shifts and scheduling of spaces. We're allowing work from home. Even Apple has decided what days you can work from home. It's going to be Wednesday at the golf course with the doctors, because Wednesdays everybody is off Apple to work from home. So what we're trying to do now is take the space that we have and make it more appealing to bring tenants back to, workers back to the office, but also to make it more efficient. And these are techniques that we're seeing in design and through surveys and testing what people want in their office space and how many days a week they want it. I call it planning for Wednesday. Everybody wants to be off on Friday or work from home on Friday. Monday is also not very popular because of commute and long weekends, but most people want to be in the office on Wednesday except for Apple. So you have to allocate your space use to how many people are going to be in the office on the peak days, which is typically Tuesday and Wednesday. increased vacancy and less demand have lowered rents. That's the good news. And the tenant improvement allowances reflecting the huge increases in construction costs have gone up. We are seeing triple-digit tenant improvement allowances, and rents, especially for technology space, has decreased 25% or more, especially in subleases. We're seeing free rent back in the market again, and tenant incentives, use of the amenities that Marsha and I talked about, use of parking, free rent to be used to credit against rent or for additional TIs. And those kinds of things have been out of the market since 2017. They're strongly back in the market, reminiscent of other downturns in the marketplace. And Jonah, you may want to talk briefly about securitization, since we.
Yeah, I'll just chime in here to say that, it seems to me in the limited experience I've had with these issues coming up recently, that letters of credit are definitely becoming more popular or popular again. Is that similar to what you're seeing, Margaret?
Well, we saw that in 2001 that letters of credit were very popular because the court said that cash was actually an asset of the tenant. And so today, letters of credit are back, and we also seeing bifurcated letters of credit, where some is allocated toward securitization of the TIs, and some is allocated toward the securitization of the rent stream. But today, because of the vacancy, Jonah, we're seeing that the amount of cash and security deposits by landlords has dropped down. If you have a good credit record, you haven't missed rent payments, you haven't tried to renegotiate and get abatement, people are taking tenants more seriously that have that kind of a credit history. So a bit lower than pre-pandemic levels. Next slide, please. So the construction materials and government delays, the impact on the market has been tremendous. I'm sure there are a number of landlord reps here that have tried to get projects done. It's a nightmare. It can take 6 to 9 months to get a permit in San Francisco. Demo permits used to be walk up to the counter, you walk out with a demo permit. Now it can take 4 to 6 weeks to get a simple demolition permit. So we're hoping this is a temporary condition, but since permitting online was not successful and permits require on-site walks, having the government back in business as of today is good news for landlords and tenants trying to do remodels and create occupancy dates that are anywhere close to the original targets. Because of the construction materials not being received in a timely way, the supply chain disruption that Marsha mentioned, certainly the backlog is still there. It's interesting to walk through a partially built space and everything is there except the framing around for the glass. Aluminum framing can be 12 to 15 weeks in backlog. I reached out to my friends and client, Hathaway Dinwiddie Construction Company, and I got some great quotes on what's going on. So steel studs for framing and for walls are now up 35% with an 8 to 10 week backlog. Glass is still $180 a lineal foot, but that's up 15% from pre-pandemic levels. We're seeing lumber up 300%. I'm sure everybody in the home building business already knows about that, but even sheetrock is up by 20%. But the big thing is the delays on delivery and being able to get the material there when you find people to install the construction. So the answer that we need to address in post-pandemic is the old rule was if you were going to have a lease, you'd look 1 year out to make sure that you had time to search out space, have an alternative, negotiate documents, and then 6 months for design and construction. Today, we're saying that if you have a significant lease, you really need to look 18 to 24 months out. Otherwise, you won't be able to make any kind of timeline. And so what I'm talking to my clients about is start early, pre-order, negotiate with your landlord for renewal early. Most landlords are willing to talk now to tenants whose leases expire 2 years out because they don't want to wait for the market to rebound. They want to have good tenants in place for the long term. But Jonah, if you had anything else you wanted to add here, I'd like to send it back to you.
All right, yeah, I just to echo that last sentiment, I think that's absolutely true in terms of looking a little bit farther ahead down the line prior to a lease expiration. That's definitely what we're seeing as well. And so with that, I'd like to say thank you to Margaret and to all of our speakers today. That was fantastic.